Welcome back to Legalese 123, where we are covering cases across America. Well, welcome back into Legalese 123. Wow, there's a lot popping off today. Wasn't expecting to do so many recordings today, but here we are. See, law can be very super exciting. So this is the long-awaited civil trial for Karen Reed. We're going to discuss it here in a second. Just want to reiterate to you, if you like what you see in this content, please like and subscribe. I'm hoping to get to 50 subscribers by the end of this month. We're at 23, but we got to get those numbers up. So today is Tuesday, November 18th. Welcome back to Legalese. First, we were talking about the Brian Walsh case. Lots going on there. Karen Reed finally files her civil suit. Who is she suing? And what does she allege? Ooh, let's get into it. I can't wait. So let's go ahead and share this to the screen. All right, let me get everything together. Just going to move this down. That is not the one that's connected. Hold on just a moment. Are you connected? No. This is the one that's connected. All right, hold on. Some technical difficulties here, but we will get through this because we want to read this together. Yes, we do. All right. Karen Reed is suing Michael Proctor in his personal capacity. Remember, he is no longer a Massachusetts state trooper. He has been fired, probably because of her. Yuri Buchanan in his personal capacity, Brian Tully in his personal capacity, Brian Albert, who is married to Nicole Albert, Jennifer McCabe, who is married to Matt McCabe, and Brian Higgins. Who are these people? Michael Proctor, Yuri Buchanan, and Brian Tully are three Massachusetts state police officers. Remember, Michael Proctor is no longer a police officer. Brian Albert and Nicole Albert are the homeowners at 34 Fairview, where John O'Keefe's body was found on their lawn. Jennifer and Matt McCabe. Jennifer is sisters with Nicole Albert. They were at the party that night at 34 Fairview. And Brian Higgins is an ATF officer who was at the party as well. So let's just get into it. All right, for 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and is subjected to suspicion, arrest, 2 prosecutions, public condemnation, all resulting from the gross misconduct of the Massachusetts State Police and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those. The Massachusetts footnote 1, the Massachusetts State Police and Town of Canton will be added as defendants after presentment is made. Plaintiff intends to move to consolidate this action with the related action of the estate of John O'Keefe. Okay, so Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who objectively failed to ensure the justice was sought and served in the aftermath of January 29th, 2022. Karen Reed did not kill her then-boyfriend, Mr. O'Keefe. Rather, in the early morning of January 29th, Mr. O'Keefe was killed in the defendants' Brian and Nicole Albert's home at 34 Fairview. Oh, she just laid it down. Woo! She is accusing them of killing John O'Keefe. Whoa. This is gonna get so good. Okay, Mr. O'Keefe was killed in the defendant Brian and Nicole Albert's home at 34 Fairview in Canton in an altercation during a late-night house party with the other defendants. Collectively, they called the house defendants. After a night of heavy drinking, the house defendants responsible for Mr. O'Keefe's death some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about how long to die in the cold. Okay, so I'm going to pause there for a second because if you remember, Jen McCabe had uh, Google texted that uh, in the early morning hours, possibly around 2:30 in the morning. She says it wasn't until 6 a.m. Moved Mr. O'Keefe's body outside and placed him on the Alberts front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Alberts lawn until Karen Reed found him later in the morning. From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. The House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House Defendant Brian Albert was a longtime Boston police officer, and House Defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosive, aka the ATF. Adhering to the unwritten rule of protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash on the back of his head, suggesting that he was punched and fell backwards, hitting his head on a ridged surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones, or even a bruise on his leg, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find him a person struck and killed by the impact from a 3-ton vehicle. So remember, as you might recall, Karen Reed, the medical examiner, couldn't determine the cause of death. She said it wasn't. She couldn't determine the cause of death. So let's continue. All right. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsies for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of vehicular strike. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house. Remember that? He never went into the house. That is very, very interesting. He never went into the house. There have been many text messages. I think that was a text message sent by Matt McCabe to the group text to the family of the Alberts. All right, let's continue. All right. Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he, Brian Albert, is a Boston cop, and that Proctor was determined to make the investigation cut and dry by bringing charges against the girl. Remember, these were text messages that were from the federal TUI dump. Remember, the feds got involved in Karen Reed's case. We're not sure exactly why. Were the feds investigating the district attorney's office? Were they investigating MSP? We do know that there was the CDL scandal. We know that they were investigating Karen Reed. There's the Sandra Birchmore case that they're involved with. So, who exactly were they investigating? We don't know. Are the feds still investigating? We don't know. Federal investigations are secret until it comes out that they've gone and charged someone. So, let's continue. Indeed, Proctor made his intentions clear in writing. Karen Reed had zero chance of skating. She's fucked. The pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on Albert's lawn, and Proctor had not even walked into the house. Now, that is in dispute as well. So, when we learned just recently that they had a GPS tracker in their cars, um, it could he have gone there? But we do know that he used his personal vehicle that day because remember it was snowing, so he used his truck that day. So we don't have that GPS information. But remember that Proctor's phone got downloaded, his personal phone got downloaded. Is there location data on his personal phone? That will be very interesting. Did he go to 34 Fairview on that day? That is a controversial statement. All right, let's continue on. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash on the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without a hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminologist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Albert's German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. So, if you're not familiar with the Karen Reed case, they had a dog that was prone to attacking, and they rehomed the dog. So shortly after, so they got rid of their house, they moved, and prior to that, they got rid of their dog, and the dog was sent to Vermont. Coincidence? Again, we were talking about the donut theory, the powdered donut theory. You take a bite of the powdered donut and you go and you touch the next person and the next person, the next person, and each person has the residue of the powdered donut on them. And this just, I mean, there's so many coincidences that just keep adding up. And what does it mean? Sometimes coincidences don't mean anything, right? Sometimes they do. Let's continue reading. Neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or faces, or bruises on their bodies. They did not seize or search the House defendants' phones. So, again, when Karen Reed's defense team, they wanted to secure Jen McCabe's phone. Jen McCabe gave her phone up voluntarily, but she was able to delete some things off of her phone. She said she deleted some text messages, but if you go through Karen Reed's case, she also deletes some other things as well. They say she can't, but she did. It clearly states she's deleted something. Again, coincidence, suspicion. Then they wanted to do a preservation request for Brian Albert's phone and Brian Higgins' phone. On the day that they were getting ready to get that preservation order, Brian Albert magically upgraded his phone, and his other phone, gone. All the data information, gone. Brian Higgins admits that he took his phone to the FBI, one of his federal friends, downloaded information about text messages between him and Karen Reed that he felt was relevant to the case. Again, who's investigating who here? He took those text messages and gave it to the police, just downloaded just that information. And then he said that he took his SIM card out of his phone, snapped it in half, went to a military base, threw the SIM card in one dumpster and his phone in the other. Why? Is is that a coincidence? Is that suspicious activity? Perhaps it had nothing to do with the Karen Reed case, right? Perhaps it has to do with their own dealings, right? Maybe Brian Albert as a police officer, maybe he's done some misdeeds. Maybe Brian Higgins as an ATF officer has done some misdeeds. Okay. Or did they cover up the murder of John O'Keefe? I have questions. You have questions. Hopefully, we get some answers. Let's continue. All right. They conducted only pre-functionary, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. Okay, again, what does that mean? Proctor, they did not have body worn cameras. They did not do separate interviews with people. They recorded 0 conversations with the Alberts, the McCabe's, the other people who were in the house. Brian Albert Jr. had a whole bunch of friends over. They did not conduct any on camera interviews with them. They did not do an on camera interview with Brian Higgins. They didn't do one even with Karen Reed. Let's continue. They permitted would-be witnesses to communicate with each other and coordinate their stories before former interviews. All right, so we found this out as well in the Karen Reed trial that Jen McCabe was trying to put together a timeline, and Carrie Roberts, who is John O'Keefe's friend, came over and helped them put a timeline together. And what this means was before they did a grand jury, like this was like day 2 or day 3, they were putting a timeline together. And when they're doing this, they're corroborating their stories. Who said what? She said what? They said they did this, and what have you. And we found out in Karen Reed trial number 2, in the presence of doing this, Carrie Roberts was influenced. Her testimony was influenced in the grand jury based upon her conversations with Jen McCabe. That was an incredible, incredible discovery that she admitted on the stand. Again, coincidences are adding up. Let's continue. In short, by focusing the investigation solely on Miss Reed, as implicitly directed by the House defendants through the through the misrepresentations they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device, and used his sister as a conduit. Whoa. Is this the first that we're getting from here? I think we had some indications of this, but is this part of the 10 million messages from his personal phone? I wonder if we're getting a little taste. Ooh, let's continue. But also, he said he's using his sister as a conduit. So his sister is friends, I believe, and don't come for me in the chat. There's so many people. I'm trying to keep it together in my head. There are so his sister, I believe, his sister is Courtney Proctor, I believe. His wife is Elizabeth Proctor. And Courtney is friends, I think, with oh goodness, what's her name? With Chris Albert's wife, Julie Albert. I believe they're friends. That or Elizabeth Proctor. Anyways, that's kind of who we're talking about. His sister was a conduit and was talking to one of the Albert family members. I believe it's Julie. If not, it'll come out. We'll find out who it was. Let's continue. All right. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend. See, I just kept reading. Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed the same information onto the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in the matter that intentionally avoid implicating the House defendants and singularly focused on Miss Reed. So remember, she said, "Oh, you're doing such a great job. I'll buy you a gift." And Proctor texted her back and say, "Don't buy me a gift. You can buy one for Elizabeth because I've been dealing with this and haven't been with her and the kids." And again, gifts to Massachusetts State Police is against their rules, as we found out in the CDL scandal. Let's continue. Proctor then went as far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and on Miss Reed's vehicle to support the false narrative that Miss Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with physical altercation with a dog attack. Okay, so we have to unpack this statement. That is a very inflammatory statement, right? Do they have anything to back that up? Now, we do know that there was a piece of glass found on Karen Reed's back bumper. I think this is what they're implicating that he had planted. The glass, which could, so they're implying that he had gone to 34 Fairview, he found some glass on the road, and then he picked that up and put that on Karen Reed's car, hoping that potentially, again, this is an alleged accusation, that it matched either her taillight or it matched the glass that was recovered underneath John O'Keefe's body. That's one part of the implication. The other implication here, I'm wondering if they feel like so it is alleged that her taillight was only cracked a little bit. It wasn't completely demolished in the photographs. And the Officer Barrows, who was a Dighton police officer who helped transfer her car from her parents' house back to Canton PD's Sallyport, he said that when he saw her car, it wasn't as damaged as the pictures that came out at trial. So they are alleging that somehow or another in the Sallyport garage, somebody busted her taillight even further, took those pieces, spread them at 34 Fairview at various times throughout the weeks. And could Proctor have been one of those people that did that? This is what they're insinuating. Let's continue on. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered. Exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed was a whack job, see you next Tuesday, retarded and nutbag, and a babe with no BUTT. Proctor further ridiculed and, I don't know what this word is, derided Miss Reed for her serious medical condition, stating that her balloon knot leaked poo, and other private text messages to his MSP supervisors and colleagues. Proctor bragged that while conducting a search Miss Reed's phone, he was looking for naked pictures of Miss Reed. Disappointed, he reported that there were no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully, she kills herself. That is what he texted to his sister, that hopefully she unalives herself so that the investigation doesn't have to continue on. I'm not sure exactly. This was early on in the investigation, like 10 hours, 14 hours, 16 hours in, that he's making these statements. It is ridiculous. Let's continue. Indeed, Proctor's supervisor and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yuri Buknik, responded with a thumbs up emoji to a text calling Miss Reed retarded. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants, the Commonwealth secured two separate arrest warrants for Miss Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only plaintiff, underlie plaintiff's meritless wrongful death claim against Miss Reed, but they also form the foundation for Miss Reed's claim against the defendants. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Acts, as well as established Massachusetts tort principles. On June 18, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory in part because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe, and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Miss Reed was ultimately and finally acquitted of all charges related to Mr. O'Keefe's death, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not Miss Reed. I love these statements, and you can see that this was written by Alan Jackson. This has Alan Jackson all over it. Alan Jackson was one of her lead attorneys in trial 1 and definitely trial number 2. If you haven't watched those trials, eventually when we have slow news, we might go back and watch it. But man, things are just popping off. Let's continue. In response to the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as Colonel, the state police has and will continue to improve in these regards." In an interview with the Boston Herald, Noble acknowledged the systematic nature of MSP's conduct in the Reed case. I'm eyes wide open to the cultural issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Miss Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP trial board found Michael Proctor guilty of a Class A violation, which included that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts State Police in disrepute. Miss Reed's life was not merely turned upside down by MSP and the House defendants' misconduct, it was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, right, so let me pause there. So Karen Reed was a very successful person, right? She was a trader. I want to say Merrill Lynch, but I think that's wrong. And then she was also an adjunct professor. So she was teaching finance courses. She had a beautiful house in Mansfield, Massachusetts that she owned. She had to sell everything. She her car was taken away from her. She wasn't able to drive. So she had to sell everything. She had to dip into her 401k just to pay for her defense team. And she's still paying for it to today. So, well, let's continue. All right. The years of uncertainty and imaginal emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family have received justice. His killer or killers still walk free. By asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants, Miss Reed seeks at minimum to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Oh boy. Oh boy. Wow. Wow. So, that is a really good statement. So, is Michael Proctor a bad seed? Is Yuri Buchanan a bad seed? Is Brian Tully a bad seed? These particular MSP troopers that are in this Norfolk DA's office, they're not currently right now. They've all been displaced. That's for another stream I have getting ready to go. Wanted to do it this week, but everything keeps popping off. So look forward to that. We're going to revisit who's who and where are they now, as I did for the Canton police. So, long story short, there has been a lot of speculations and a lot of whispers, rumors, innuendos, and factual information about these MSP troopers and their investigative processes. So, this is just the Karen Reed case, right? Sandra Birchmore, we'll talk a little bit about her. Sandra Birchmore passed away. They said it was she had unalived herself. Some of the MSP troopers involved, like Guarino, for example, had, and Proctor was involved too, was investigating her death, and they had gone through her text messages and stuff, and they said, nothing to see here, nothing to see here. And they said, up, she unalived herself, move on, nothing to see here. Well, her parents were like, she was pregnant at the time. She was getting ready to have a baby. She had just gone and cleaned off her car. So when you look at an unaliving case, you look at what was the state of mind of this person, and did they have the means and the mental capacity to unalive themselves? And her parents were like, there's no way she would have done that. So they pushed for a further investigation, and turns out, wow, there's 30,000 messages between her and other trooper or other police enforcements in other counties. I believe in Stoughton. I'm not 100% sure. Don't quote me on that. We'll go back to Sandra Birchmore. We'll do a deep dive on that. But long story short, Matthew Farwell, who is a police officer in another police barrack, is being charged with the death of her, with her death as well as her unborn child. If you're not saying WTF right now, you ought to be. So I like this statement that trampling the innocent, because they've been doing it for all this long. Do they do this in every case? Are they circumventing the policies and the procedures just to get the bad guy? Are they making up evidence? Again, we're talking about coincidences. We're talking about their policies, their procedures. Why do they follow things in one case and not follow them in the other? We've Brian Walsh's case coming up. Was there some impropriety there? We do know that there's text messages in there. Was he biased against Mr. Walsh? Was he looking for nudes for Anna Walsh? What's going to come out in that trial in reference to MSP and those officers? Because again, those same officers are involved in Karen Reed's case. Miles King, he's got some stuff coming up. So there's a whole bunch of cases that Proctor's involved with, 19 plus, that are currently pending, that Michael Proctor's got his hands all over in that. And if you find bias in one case, that can just resurface and resurface and resurface. And again, we talked about the bad guy effect, right? So if Michael Proctor's indiscretions keep coming up, and it lends to the fact that he was biased and he might have curtailed his uh, investigation to prove that this person was guilty, that can be used against him, and that could actually let the bad guy go free, right? Does the Commonwealth want that? Do they want to have these trials where they think that they can get a conviction and just let the bad guy go free, even though you honestly know that this person might have committed this crime, right? Do we want bad guys to be set free from the indiscretions of police officers who were too lazy to do their job? This is the core aspect of what is happening here. So, like I said, there's about 19 current cases that Proctor has his hands all over, and I'm sure all these other MSP troopers have their hands in as well. We just don't know to what extent just yet because they haven't come out. But what about anybody prior to this? Is there possibly somebody who is sitting in jail who is innocent because somebody may have planted evidence, right? Somebody changed the narrative to make it be that this person's guilty, and oh, here you go. What if somebody pled guilty because they didn't have the defense team that Karen Reed did? Karen Reed is extremely, extremely fortunate, right? She had the ability to hire an A-plus team of lawyers to go through her case with a fine-tooth comb and point out the indiscretions from these troopers, from the people in the house, et cetera, et cetera, et cetera. And they had the audacity not only to try her once, but try her a second time, knowing the evidence that they had against her. Such impropriety. And I am so thrilled for her that she is going through this lawsuit. We don't know what's going to come out of it. We don't know if they're going to settle. We don't know if this is actually ever going to go to trial. But here's what she is alleging. So Karen Reed is finally, this is what I feel. Karen Reed is finally able to make a pure statement. She is talking through her lawyers, which is amazing. So I'm going to stop my diatribe and we're going to continue on. All right. Parties. Plaintiff Karen Reed is an individual residing in North Dighton. She lives with her parents because she had to sell her house. Defendant Michael Proctor is a former Massachusetts State Police trooper residing in Canton. He is being sued in his personal capacity. Defendant Sergeant Yuri Buchnick is a Massachusetts State Police residing in Stoughton. He is being sued in his personal capacity. Defendant Brian Tolley is a Massachusetts State Trooper residing in Hingham. He's being sued in his personal capacity. Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, Brian Higgins. Jurisdiction and venue. This court has jurisdiction over the claims in this case pursuant to blah 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 blah. Venue is appropriate. Facts common to all counts. Before his death, Mr. O'Keefe and Miss Reed were dating. On the evening of January 28th, 2022, Mr. O'Keefe and Miss Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. There, they met up with a group of acquaintances, Brian Albert, his wife Nicole Albert, Brian's brother Chris Albert, and his wife Julie, Jennifer McCabe, Nicole's sister and Brian's sister-in-law, her husband Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview, aka the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relations. At the time, Brian Albert was a Boston police officer as well as Mr. O'Keefe. Though they did not know each other well, Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton Police He was also permitted to keep an office at the Canton Police Department alongside Brian Albert's brother. Canton Police Detective Albert and Kevin Albert had a professional social relationship with Michael Proctor. All right, let's pause there for just a second. So, as you may know, everybody knows everybody, right? We've already cleared that up earlier in this document. Everybody is from Canton, right? They went to high school together. Some of them had gone to college together, whatever. Let's talk about Brian Higgins for just a second. As it states here, Brian Higgins had an office at the Canton Police Department. Why? He's an ATF officer. Isn't that federal? Why is he at a local police department? So he had access to the Canton Police Department. He had access to the Sally Port on the night of that her car was delivered to the Canton Police Department. He went back to the Canton Police Department that evening around 1:30 in the morning. And the first trial, Karen Reed didn't know about that because the Sally Port video was tampered with. I'm just going to go ahead and say that. I believe that it's been tampered with. And remember, it was inverted, then it wasn't inverted, and they're missing segments and pieces to it. And then they totally didn't get the fact that Higgins had gone back to Canton PD. Later, it was disclosed via Hank Brennan and Karen Reed's second trial that the downloaded version of all of the videos pertaining to Karen Reed during that period were in a file from Michael Proctor. But later on, it came out that Yuri Buchnick had reviewed some of the file footage, so he knew about it. So again, we talk about coincidences and suspicious behavior. Why? Why? Does it prove that they wanted to cover up some things? They wanted to hide some things? Why? Let's continue on. It's going to get more ridiculous. All right. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. Miss Reed and Mr. O'Keefe had never been to the house before January 29th, 2022. They arrived in the front of the Alberts home at 12:20 a.m. Miss Reed was reluctant to attend the party for several reasons, including that she was unsure whether or not they were at the correct location and whether they were even welcome to the late night party. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked toward the front door, garage door area of the house and entered one of the two doors. A period of time passed without any word from Mr. O'Keefe. Miss Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him. At some point after entering the house garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Alberts German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating counter-coup wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backward and striking a ridged surface. The Alberts garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts. Because of their knowledge of their criminal investigation, the Alberts, the McCabe's, and Higgins, House defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the five of them agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired. Mr. O'Keefe never entered the house and hide evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the front lawn from potential passerbys. Now, why is this important? As we had discovered, there was a snowplow that came out that evening. Remember, there was a huge blizzard. And if you haven't seen trial number 1, you know that was Adam Lawley's number 1. It was snowing outside, right? There was lots of, it was snow, 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 right? It was interesting that, again, in the investigation into the death of John O'Keefe, that the MSP troopers stopped at Karen Reed and didn't really go any further. It was, da 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 da, say it with me, Aiden Carney, Turtle Boy, who found Lucky Lochran, who was the snowplow driver on 34 Fairview. He is very familiar with the Albert family. He worked at D&E Pizza, which is Chris Albert's pizza shop in Canton, so he knows them. He knows the Brian Albert's location because he delivered pizzas there, and I'm sure he had some interaction with them. Lucky Lochran claims that there was a Ford Edge parked in the vicinity of where Mr. O'Keefe's body was found on the lawn. Lucky Lochran stated that he knew for a fact that it was there, and he believed that Brian Albert owned a Ford Edge. It's typical police issued vehicle, right? And that Mr. Lochran had stated in his testimony, both in trial 1 and trial number 2, that there are not supposed to be any vehicles parked on the on 34 Fairview because when the snow plows go through and a blizzard situation, they need to be able to clear the road. There was a Ford Edge parked there, and he discounted it. He was supposed to call his supervisor and say, hey, there's a car here. They either call the homeowner or they have it towed. I'm not sure exactly the procedure, but you're not supposed to have your vehicle parked on the street when they're plowing. And that is how he knows that there was a Ford Edge there. So this is where that comes in. Let's continue. And that can be important because Lucky Lochran puts a Ford Edge there at that time because Lucky Lochran said he did not, because he went by and plowed it, and he did not see a body on the lawn. I also have to reiterate, when everybody else left 34 Fairview, Brian Higgins left. He said he didn't see a body on the lawn. Jen McCabe and Matt McCabe took 2 of the other Brian Albert Jr.'s friends home. They didn't see a body on the lawn. One of the other Brian Albert's friend's brother had come just around the same time Karen Reed had come. He didn't see anybody on the lawn. And when some of the other people left, nobody saw a body on the lawn. It was dark outside. Didn't see a body on the lawn. And there's even video evidence of people sort of like backing out with their lights on, and the lights would have shined directly into the area where John O'Keefe's body would have been, and clear as day. Anyways, we'll go back to that later. All right. So, at some point further in the night, they carried or dragged Mr. O'Keefe's body to the same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of exposure to the cold. And remember, when the medical examiner testified, she said he had no hypothermia. So what does that mean? If he was on the lawn, let's say 12:30 at night, we're just giving a rough estimate, and they didn't find him until 6 a.m., that's, 5.5 hours, right? And she said there was no hypothermia. So that one could assume that if he was put on the lawn at 3 a.m. approximately, then he was only outside for 3 hours. Let's continue. Mr. O'Keefe was either dead when the House defendants left him on the Alberts lawn, or he died shortly thereafter. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some administrative work, but then changed his story subsequently, stating that he drove to the station because he had to move some cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:20 a.m. This is very important as well because throughout the trial, both Brian Higgins and Brian Albert claimed that they had butt dialed each other. Brian Albert said that he was having sex with his wife at 2:30 in the morning after a full day of drinking. And when I say full day of drinking, he and Brian Higgins had gone to New York to go to a funeral of a fellow fallen officer. They then stated that they had come home in the afternoon hours around, let's say, 3 or 4 in the afternoon and started drinking. So they started drinking around 4 a.m. and were at the Waterfall Bar until midnight. Wow. Count how many drinks, and you can figure out what their level of intoxication was. So at 2:30 in the morning, Brian Albert is supposedly having sex with his wife, and he puts his phone in the middle between the two of them, and it magically answered Brian Higgins thing via butt dial. That must be some pretty interesting moves that he is making to butt dial his friend in the middle of sex. We'll continue on, but I found that very funny. Again, suspicious coincidences adding up. All right, let's continue on. Later, both Brian Albert and Higgins denied the existence of these phone calls, and when confronted with their existence by a separate law enforcement agency, the FBI, a non MSP and non CPD law enforcement agency, the FBI, at a separate proceeding, the federal investigation, the federal grand jury, they coordinated the same exact lie, falsely claiming that multiple calls between and answers were just butt dials. However, 5 minutes after Higgins and Albert called, Miss McCabe performed a Google search on her phone at 2:27 a.m. House long to die in the cold, misspelling the first word. All right, we got to pause there and talk about that. Okay, so again, coincidences adding up, controversies, whatever. Jennifer McCabe is at home by now. She claims that she was on her phone and she was uh, doing something called Hakamak Sports, and she was downloading or looking at the schedule. And that is when her phone was opened. Celebrite and Ian Whiffen claim that Google tab was open. And at 6 a.m., when she was with Karen Reed, and she claims that Karen Reed asked her to Google how long to die in cold, like how long, if your body's out in the cold, how long does it take to die? She claims she did it at 6 a.m. at the behest of Karen Reed, but nobody can corroborate that. None of the police officers, not even Carrie Roberts, can corroborate that. But that tab was open from her 2:27 a.m. search. So, did she make that search at 2:27 a.m.? In the defense case, in Karen Reed's case, they had an expert that said, yep, she made that search at 2:27. Ian Whiffen and Celebrite, who, so you have so I told you your cell phones lie on, tell on you, right? All the information, etc. But as these companies, Celebrite is going through and downloading and looking at your information, technology isn't 100%, right? So one can say she did it at 2:27. Celebrite says, oh no, she did it at 6 a.m. But I think that Celebrite couldn't articulate clearly as to whether or not she did it at 2:27 or at 6 a.m. And so now it has come out that Ian Whiffen and Celebrite have completely have gotten rid of that conclusory discovery of if this tab is open, what was the timestamp that they did it. And of course, Celebrite is a secondary software system that downloads all the stuff off of your phone, and they have software that goes through it. Things can be wrong, right? Nothing is ever certain. But this question came up in this trial, right? Technology is ever evolving, and we're going to continue to have more questions as things evolve, as they are downloading and analyzing people's phones. Apple is the proprietor of your phone. Apple has their own software and they will not divulge any information to anyone because it's proprietary to them. So this secondary company, Celebrite, Ian Whiffen in particular, came out later on and said, we just deleted it. And I'm like, you can't explain this wholeheartedly. You can't. So it's one of those anomalies. It's another one of those coincidences. You're trying to explain away whether she did or did not make that Google search at 2:27 versus 6 a.m. You can't articulate 100% that she did or she didn't, even though you're on the stand and you're making up some googly gobbly stuff, trying to convince people that she made that search at 6 a.m. versus 2:27 a.m. And boy, did they really put on a show that no, this isn't possible. It's only at 6 a.m. Sus. I find it sus. And then now you've come out and you completely deleted it. I I I don't I just can't. I just can't. And then you go on and you celebrate that how great that you are. No, thank you, Mr. Ian Whiffen. No, thank you. I'll continue on. Miss Reed searches for Mr. O'Keefe. Miss Reed began the search of Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized that he had not returned home. She phoned House Defendant Jennifer McCabe, who already knew exactly what happened to Mr. O'Keefe. Miss McCabe insisted that Miss Reed drive to Miss McCabe's house rather than driving to 34 Fairview, which Reed did. The two of them were then joined by Carrie Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, Miss McCabe directed them to go back to Mr. O'Keefe's home, where Miss Reed had just come from. After the three of them finally drove to 34 Fairview, the illogical McCabe directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. Ooh, that is a very interesting allegation. That is very interesting. I didn't think about that. Could she potentially have been misdirecting Karen Reed to drive all around, wait for Carrie Roberts and what have you, so that the Alberts can get their stuff together? Interesting. All right, let's continue on. So as they approached the house with Miss Roberts driving, Miss Reed saw Mr. O'Keefe almost immediately. She screamed for Miss Roberts to stop the vehicle and jumped out of the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was discovered on the front of the Alberts house near the flagpole and by the fire hydrant on the left side of the Alberts property, as seen from the roadside. The Ford Edge, which has been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. While Miss Roberts joined Miss Reed with administrating CPR, Miss McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that there is a man passed out in the snow. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house. Miss McCabe never went inside the house or requested that the Alberts come out to help Mr. O'Keefe. Rather, Mr. O'Keefe lay dying in the snow. Miss McCabe stood and watched with no fear, urgency, or any concern for her family members residing a mere feet away. So, this is what was alleged in the trial that Mr. Alan Jackson had purported, was that, if you have a friend who comes to your house for a party and something happens to him, you want to know, like, what happened? Did he go into the house? Did he come out? What was the series of events? And he's stating that her actions, right? Because actions matter, right? Actions and words matter. And that she was just sitting in the car. She dialed 911 and she stated that there's a man passed out in the snow. She didn't go inside the house and be like, "Hey, Brian and Nicole, hey, John O'Keefe's on the front of your lawn. Come out and help out. WTF, what's going on? Hey, there's something happening." She wasn't panicked in that respect. So, does her behavior lend to suspicious activity? Coincidences are adding. I need to make a song. All right, let's continue. Canton PD were the first ones on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, torso, or any part of his body as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking CPD officer at the scene, Sergeant Michael Lank, opined on a telephone call captured on his dash cam that Mr. O'Keefe looked like he had been in a fight. Interesting. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn of 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's screams upon finding Mr. O'Keefe's body, no one from the Alberts home, including police officer Brian Albert, who was a first responder, ever went out of the house to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. Ooh, let's pause there. All right, so we just talked a little bit about the suspicious behavior behind Jen McCabe, right? So let's talk about the suspicious behavior for Brian and Nicole Albert. Now, understandably, Brian Albert had been out all day drinking. So finally he goes to bed at 2 or 3 in the morning, right? So he's probably dead asleep. But on the dash cam video, you can clearly hear Karen Reed is screaming at the top of her lungs. You hear the police cruiser outside. You see the lights flashing. You hear all of the commotion going on. They don't even come out. Even when, I forget which police officer, I think it might have been Gallagher, told Jen McCabe to go into the house and contact Brian Albert and his sister Nicole, none of them came out. Not only that, where's the dog? You don't hear any dog barking on any of these police dash cam videos. I'm sorry, I have a German Shepherd. My German Shepherd, when he barks, you can hear him. So when in the trial testimony, when Jen McCabe had gone to see Brian Albert and Nicole Albert, they said that their dog slept with them. And when Jen McCabe went inside, the dog didn't bark. I'm sorry, so many coincidences are just adding up. If you're not like, what the heck is going on? Let's continue. All right. Sergeant Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. Said Gallagher is Lank. He spoke to the Alberts and the McCabes. Pursuant to their plan, the Alberts and the McCabes told Sergeant Lank that Mr. O'Keefe had never entered the Alberts' house at the night before. The Alberts and McCabe's statements were false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts' dog, and suffered fatal injury to the back of his head. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling him, neither Sergeant Lank nor any other members of CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death. Nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of a bias born of friendship and loyalty in favor of the Alberts and the McCabe's. Ooh. By the way, I'm sure we talked about this before, but Brian Albert's brother, Kevin Albert, is a detective at the Canton PD. So let's talk about this very briefly. Where was it going to go? So Lank goes into the house to interview, to talk to them about, hey, there's a guy on your lawn. Do you know him? And that there was no other further investigation done from this. One of the things I need to note is that I talked about it earlier. Canton PD does not investigate death scenes. They say they do, but they don't. So again, there was a blizzard. If you didn't already know, hey, there's a blizzard. And Canton called MSP to come out. And they're like, well, is he dead yet? It reminds me of the Monty Python. Bring out your dad. Is he dead yet? Unfortunately, Mr. O'Keefe wasn't pronounced dead until he arrived at the hospital and they had to warm up his body. He did have a low temperature. They have to warm him up. Then they have to try to revive him, and then they pronounce him. And I don't think he was pronounced until like 8 a.m. So for 2 hours, from 6 a.m. when the Canton police, don't come for me. I'm not giving specific times. You know the timeline. 6 a.m. is when they come, to 8 a.m. is when he's pronounced. So for 2 hours, it's Canton PD's scene. What could they have done? So as they start investigating, right? And it's Sergeant Gallagher and Sergeant Good. Gallagher has retired. Good is on paid administrative leave. We think due to Proctor's 10 million texts and stuff that are coming out. Again, how the mighty are falling left, right, and center. They start investigating. Remember, the solo cups are involved. Gallagher gets the solo cups from another police officer across the street. Remember, there's ring footage camera that's mysteriously gone. And there's nothing to report there. Nothing to see. So they collect the blood evidence. They get the leaf blower. They find the cocktail glass. I think eventually, so then the cert. So there's a 2-hour window in which they're investigating. If there was an issue with preserving evidence, et cetera, what have you, understandable what they're kind of going through. But the main thing in this statement is that they didn't secure the scene. Didn't put up police tape. Didn't hold an officer there until MSP arrived. Didn't do any of that. Even MSP, they didn't buy that either. They did not secure the scene. And the scene was unsecured for the longest time. Anybody could just come through and do whatever to the crime scene. Because again, they thought it was a motor vehicle accident and they blamed it on Karen Reed. Let's continue on. All right, after Sergeant Link returned to the CPD 3 hours after the discovery of Mr. O'Keefe's body and more than 2 hours after being interviewed at the Alberts home that morning, Miss McCabe called Sergeant Link to report that she, quote unquote, recalled additional information as part of the plan to implicate Miss Reed and remove suspicion from the House defendants. She falsely told Sergeant Link that Miss Reed told her twice that morning, "I hope I didn't hit him." More than a year later, at a separate proceeding, Miss McCabe changed her story on this topic yet again. In furtherance of the House defendants' plan, Miss McCabe then falsely reported that Miss Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Proctor leads MSP investigation despite conflicts. Michael Proctor was assigned as the case officer and primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Buchnick was Proctor's direct supervisor. Lieutenant Bryant Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Buchnick and Proctor. In their roles, Buchnick and Tully both knew at all times exactly the extent of Proctor's misconduct in the investigating Mr. O'Keefe's death as described below. From the beginning, Proctor should have never been assigned as an investigating officer, let alone the lead investigator. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phone numbers. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister Courtney was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts and the Proctors as second family. The existence of these relationships was intentionally suppressed by Proctor and other members of MSP, including Buchnick and Tully, in an effort to ensure the House defendants were protected, and that Miss Reed's rights to a fair investigation and trial were undermined. Proctor, Buchnick, and Tully engage in a corrupt and biased investigation, but not investigating inside the House and interviewing House defendants as friends rather than suspects. Proctor, Buchnick, Tully, and the MSP never searched for DNA evidence inside the house, never looked for ridged surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the house defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the house defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor, Buchnick's, and Tully's interviews of the House defendants were also outside of normal protocol. They were all interviewed either at the home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each ultimately unrecorded and fundamentally designed to protect the House defendants, and the House defendants took full advantage of it. Specifically, Jennifer McCabe became the point person of the House defendant in providing their false narrative to investigators. She managed and communicated details about House defendants' messaging and the investigation itself, including Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message change that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help investigation concerning the death of the alleged friend. Rather, they were predicated acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. The remaining group texts that were not deleted or they were recovered later reveal of their planning. For instance, on the evening of January 29th, Jen McCabe texted with her sister Nicole Albert that Carrie Roberts, who was present when Mr. O'Keefe's body was found, talked to the cops and kept it simple. Of course, there would be no reason to report back to House defendants about Roberts keeping it simple unless what really happened was more complicated. Proctor, Buchnick, and the MSP never sought these communications. Rather, they were tamed by Karen Reed's defense attorneys' repeated motions to compel access to data on Miss McCabe's iPhone. Later, in group texts with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter saying, "Ask Chris some questions. Tell them the guy never went into the house." As an endorsement of the plan, Brian Albert responded, "Exactly." Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provided a window into the conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. Rather, based on media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death, another separate law enforcement agency, let's say it together, The FBI began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining the House defendant's phones, taking statements from the House defendants, and conducting a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by this separate law enforcement agency, the FBI, investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Hold for just a minute. I need to take a drink. Proctor Buchnick initially interviewed the McCabe's and Brian Albert on January 29th at the McCabe's home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. Buchnick and Proctor did not interview Nicole Albert or Brian Higgins until February 3rd, 2022. Did not interview Chris or Julie Albert until February 10th. Nearly 2 weeks after Mr. O'Keefe's death and more than a week after Miss Reed was arrested and charged. Before both interviews, the McCabe's and Alberts continued to coordinate their stories as evidence in group texts. Proctor, Buchnick, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buchnick interviewed Higgins on February 3rd, Higgins presented the troopers with a selected set of self-curated texts between himself and Miss Reed. They learned that Higgins and Miss Reed had been exchanging flirtatious texts, and that Higgins reported at least one instance in which Miss Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Rather than pursuing Higgins as a possible sex suspect, Proctor, Buchnick, and Tully neglected to investigate that matter further. They never interviewed Higgins again, even after a surveillance video revealed Higgins was suspiciously hiding his face in the halls and parking lot of CPD, Canton PD, at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchnick, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen Reed and her criminal defense attorneys for years. Reed's defense did not receive these videos until after Reed stood trial for the first time. And even after the separate law enforcement agency, the FBI, investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. When it was revealed that Miss Reed's defense team requested the preservation of Brian Albert's and Higgins' phones in order to forensically image them, this request was allowed by the court. Both men got rid of their phones within days from one another. Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from his phone, cut the SIM card with scissors he brought with him, and destroy and dispose the phone and card separately in 2 dumpsters and then drive back. Suspicious! Their destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor, Buchnick, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as a cellular toll records or simply interviewing Higgins and Albert to inquire about the nature of the late-night communications. They intentionally ignored these avenues as well. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, at least 67 times between February 1st and September 6, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Proctor shared investigatory details with Courtney before they were public. In the same instance referenced below, when his sister informed him that Julie Albert had been so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. And then after the interview, Proctor spoke to Julie on his personal cell phone to an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He treated them like family friends that they were. At one point leading up to some of the interviews, Miss McCabe asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn more from Julie Albert again through Courtney, Nicole Albert responded, "We'll get more information tomorrow." Well, to Tom, meaning tomorrow. Don't want to text about it. House defendants did not want to text about it, their activities and communications, because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that the McCabes had lied in their sworn testimony in the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Michael Lank's house. However, while they did not text about this meeting, Miss McCabe's cell phone location data obtained by Reed's defense reveals that she did, in fact, visit 34 Fairview just one day after the O'Keefe's death and lied about it. Ooh, again, I think this also goes to Turtle Boy, aka Aiden Carney. So, Aiden is an investigative journalist. He went out and found things. People tell him things. I believe this is the one where he found out that Jen McCabe and Carrie Roberts went to Lank's house, and that how he found out was that they got the license plate and they ran it. He had a friend who ran it through the system and found out that the license plate belonged to Jen McCabe, and so there was that connection. Jen McCabe and Carrie Roberts, I'm not sure exactly, lied about it and said that they weren't there. As it came out in the second trial, they were busted. Let's continue. The McCabe's, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Buchnick, and Tully accepted their coordinated statements without making any efforts to corroborate their stories. Rather than investigate their friends and brethren, Proctor, Buchnick, Tully, and MSP targeted Karen Reed. Instead of taking the routine, objective, and necessary steps in the investigating the McCabes, Higgins, and Alberts, Proctor, Buchnick, and Tully focused exclusively on Miss Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Miss Reed's cell phone and her SUV within 30 minutes of interviewing her on the 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Much to Proctor's surprise, through the separate law enforcement agency, FBI, investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSB had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSB had not at that point visited the crime scene or been inside the Alberts' home, and had performed only a cursory interview of the McCabes and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and that he had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with the vehicle strike. And he did have injuries consistent with a fight and dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner on the property where Mr. O'Keefe's body was found, would receive some shit, and agreeing with another friend assumption that you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was going to put serious charges on Miss Reed and that she was fucked and that there was zero chance she skates. From the outset, Proctor was determined to pin it on the girl. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. Oh my God, this is so Alan Jackson. He told them he knew the Alberts' text messages from Proctor and Buchnick and other MSP troopers show Proctor had decided to focus his suspicions on Miss Reed to the exclusion of everyone else. He told the troopers that Miss Reed was retarded and he was searching in her phone for nudes of her. In the text chain, Sergeant Buchnick liked Proctor's text describing that Miss Reed was as retarded. Buchnick received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Because he was determined to put serious charges on Miss Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead the manner of death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial number 1 and trial number 2 that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career he had never seen a homicide investigation where the medical examiner could not determine the manner of death. So then why are we trying her? But he remained undeterred in his quest to charge Miss Reed. As he later admitted, the medical examiner's refusal to rule out the death of a homicide did not matter to him because either way, Miss Reed was going to be charged. So I'm going to pause there for a second. So even early on, he was determined that she was going to be charged. The medical examiner didn't agree, and yet they're going full force. I believe she was charged within she was arrested and charged within 72 hours. It just baffles me. Norfolk DA's office, MSP, Canton PD. I pray that you guys get your crap together and that this will teach you a lesson that you cannot trample on people's civil rights. If Karen Reed didn't have the money to defend herself, where would she be? Would she have to have pled? Who knows? Who knows what would have happened? So what about other defendants? Did they get somewhat of the same treatment? And what happened to their fate? This just opens up so many cans of worms. Oy. Let's continue. Proctor and Buchnick plant certain evidence and make false statements in court and other legal documents to frame Karen Reed. Proctor made this investigation cut and dry by manufacturing a case against Miss Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was a violation of MSP policy, a well-established best practices for critical incident investigation. Specifically, the MSP Crime Laboratory requires proper processing of evidence at major crime scenes, including crime scene photography and evidence processing and recovery of latent fingerprint, footwear, and tire track evidence. Neither the MSP troopers involved in the investigation nor the CPD officers on the scene secured the Alberts home or the area where Mr. O'Keefe's body was found. MSP did not take any photographs of the house, including any part of the yard where Mr. O'Keefe's body was found, until February 1st, more than 3 full days later. No photographs were ever taken of inside the garage at 34 Fairview. This intentional departure from established protocols permitted Mr. Proctor Buchnick to generate false incriminating evidence against Miss Reed and give the House defendants time to destroy the actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Miss Reed or seen her Lexus SUV, Proctor had already ordered seizure of her vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the CPD Sallyport, even though the MSP has at least 2 closer barracks, and Massachusetts was in the middle of a historic nor'easter. Proctor, blizzard, everybody knows blizzard. Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than at MSP facilities, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview. Before the vehicle arrived at the garage, Miss Reed's Lexus taillight had a minor crack but was intact. The crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. The incident is captured on the ring camera video at John O'Keefe's house. Buchnick and Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after a tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear taillight was almost entirely destroyed. Video taken from different angles in the Sallyport shows Buchnick, Proctor, Canton PD Police Chief Ken Berkowitz, and other individuals near the taillight, but notably, no video captures the taillight appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as CPD access card swipe log obtained by a separate law enforcement agency, FBI, revealed seemingly unfettered access to the Sallyport by a myriad of individuals throughout the evening of January 29th, including just before and after 5:30 p.m. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then planted them in other various places at 34 Fairview on Mr. O'Keefe's clothes. Oh, this is getting good. Knowing that there were video cameras both inside and outside the Sallyport, Proctor and Buchnick worked together to obscure the role in manipulating the right rear taillight, and then ultimately to present false evidence at the criminal trial. Specifically, Proctor directed Buchnick to secure video footage from the surveillance camera located both inside and outside the Sallyport garage, which he did. These videos were manipulated into two significant ways. First, a critical 42-minute portion was deleted from the footage from the Sallyport front wall camera, the portion from 5:08:02 p.m. and 5:50:50 p.m., which included the exact time Miss Reed's Lexus arrived in the garage. This footage would have shown that the taillight was intact. Second, footage from the Sallyport back wall camera was inverted, which made the right side of Miss Reed's vehicle appear to be the left side and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but was too grainy to decipher the condition of the passenger taillight. The videos inside and outside the Sallyport, and Mr. Proctor's request for Buchnick to obtain it, was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung upon them immediately before and during the second criminal trial. Whoops, we just found it. Here it is. Don't worry, no harm, no foul. So, as you know, in a criminal trial, exculpatory evidence is supposed to be given to both sides in a timely manner so they can go through and decipher what the evidence means, get an expert to decipher what it means to present it at trial, right? Oh, no, they had bits and bobs of the Sallyport video, but magically, I need like unicorn, magically, the video appeared. Brennan said, "Oh, hey," it was found in Michael Proctor's file. But it was revealed that Buchnick if Buchnick had reviewed it and in emails that we found, he knew the existence of these videos. Proctor knew the existence of these videos. So why was it not given to them and sprung on them during trial? If that is not a flagrant violation, I don't know what is. And how did the judge handle it? She's like, no big whip. You're going to go ahead and you're going to have the evidence. You'll just bring it into this trial and it'll be all okay. She's getting a second trial. Everything's fine. What if she would have been found guilty? She would go to jail. Then she would have to wait upon appeal. Probably upon appeal, they would be like, oh, she gets a new trial. So let's go ahead and try her a third time. No, thank you. Get your crap together, people. You are violating her rights. Just mind blowing. And whose other rights have you violated? Okay, my rant is over. Let's move on. In fact, Buchnick presented one part of the video during his direct testimony under questioning by the Assistant District Attorney, Adam Lawley, in trial number 1. Buchnick narrated the video to the jury, correctly identifying that Proctor was at the rear of the vehicle, but claimed that he never approached the right rear taillight of the area of the vehicle. That testimony, however, was entirely false. As he well knew, the video that Buchnick authenticated as fair and accurate was actually neither fair nor accurate because it was inverted, meaning it was backwards. Proctor was actually behind the right taillight for a significant period of time. But because it was inverted, it appeared that the video he was behind the left taillight. They hoped this would allow Buchnick to lie about the issue at trial without detection. With this video and Buchnick's false testimony, the MSP, Proctor, and Buchnick attempted to mislead the jury in order to conceal the tampering with and planting of taillight material. Proctor, Buchnick also took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. Okay, now, there are many conspiracy theories out there as to exactly what happened. Remember, there are many sides to a story. There's one side, the other side, and something in between. You're never going to get the full answer. Do you believe that Prochnick and Buchnick planted evidence? I don't know. And in a civil case, what do they have to prove? Don't know. But again, there's so many coincidences and so many suspicious things that add up, and you're just like, no, this can't be. And this is why I started this channel, right? I was telling people about the Karen Reed trial, and they're like, no way, no way, no way, no way, no way. And every day was a bombshell. Something else came out. And you're just like, how can this be? How can she be tried? The police don't do this. Other people don't lie. Why are people lying? What is going on, right? I can't, like, you can't make this up. But yet here we are, right? I mean, this is such a Lifetime movie thing. I can't wait till they come out with their Netflix versions of whatever they're coming out with. It is absurd. Hang on, I got to take something to drink. 1 second, please. Okay. Whether you believe this or not, whether you believe Proctor and Buchnick did or did not plant the taillight throughout 34 Fairview, it is very suspicious that Canton PD was out there the first day with their snowblower, didn't find anything. The CERT team was out there. The CERT team is a search and rescue something that Proctor called out to go and do a grid search on the lawn at their 34 Fairview. And they did whatever the grid search is, and they did find some taillight pieces, but nothing to the extent that was later discovered. And so how did taillight pieces magically appear? They're like, well, the snow melted and therefore they just magically, but some of them were on the ground, on the road. How is that possible? You know that snowplows had gone through, and you know that they would, and how are they right there? Like, they would have been dispersed, right? Oh, I found taillight pieces down at 23 Fairview Road, right? No. And, sorry, I'm going to bring this up. The homeowners, Brian and Nicole Albert, never found any taillight pieces. Anybody who went to go visit them never found out any taillight pieces. I'm so baffled. I'm sorry, but if there was somebody who was on my lawn, a fellow police officer, right? Back the blue, right? A fellow Boston police officer. You're a Boston police officer. I would be combing through the ground trying to find anything that would lend to, I mean, even if it's the story that Karen Reed did it, I would be out there searching for any evidence that proves her guilt, right? No, days later, magic taillight pieces. So again, you're just like, what? How? How is this possible? Yet here we are. And also Brian Albert brought this up in a interview. He's like, how is it possible there's like 30, 40 people that would be involved in this conspiracy? I agree with you. How is it that each one of you could possibly be together in this conspiracy and pull this off, right? Now, I understand, again, everybody's got something going on, right? And they could be connected, they could not be connected. It could be ancillary to something else. But this coincidence adds to this coincidence, which equals conspiracy, and y'all are involved. You're involved with something. Let's go on. All right. And warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of Google electronic records, ring videos, Miss Reed's phone, Miss Reed's vehicle, cell tower records, and other sources of information. Proctor swore he seized Miss Reed's vehicle from her parents' home at 5:30 p.m. on January 29th and had the vehicle towed to CPD. Reports shared by Dighton Police Department in 2023 revealed that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Miss Reed's vehicle, bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police Report revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor at the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Buchnick drove them around in his car all day and placed them in the Norfolk County District Attorney's Office for at least 6 days, where they were accessible to Proctor, Buchnick, and any other MSP troopers. Proctor and Buchnick failed to create a log to document the chain of custody of clothing. Therefore, and by design, there's no record of when, how many times, and under what circumstances Proctor and Buchnick touched, manipulated, handled, and otherwise tampered with that clothing. The MSP Evidence Submission Handbook dictates the chain of custody begins at the time of collection and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Here, in a violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, did not begin until March 14th, 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP Crime Lab. At some point before providing these clothes to the crime lab, Proctor and or Buchnick placed pieces of SUV taillight on them where they were identified by the crime lab in 2023. Okay, so let's talk about this really quickly. So, it was stated that John O'Keefe was found in the snow, so his clothes were all wet. When Proctor picked them up, this is what Proctor stated on the stand. He picked them up, they were all wet. They were in his car the whole day because they went to go find Karen Reed, did all that stuff. Then he placed it in the Norfolk District Attorney's Office. Again, didn't properly record his findings. He said that he laid them on a butcher paper for them to dry out. But here we are, 2 months after it's been collected. Does he like bag and tag it and send it to the crime lab? Suspicious coincidence. I wished I wish I would have made a list of coincidences and like put them all together, but let's go on. We'll find some more. All right. Proctor also planted pieces of glass on the bumper of Mrs. Reed's SUV while it was in his possession at the CPD's Sallyport garage, which he then claimed to have recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall bar. Eventually, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing of the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the five glass pieces originated from multiple different sources. One shard of the glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have been ended up on the SUV's bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. And other aspects of the conflicted and corrupted investigation. Proctor, Buchnick, and MSP investigators was rife with other examples of corruption and bias. For example, despite the evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchnick or any other member of MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. Proctor and the MSP failed to track down other important witnesses and evidence. For example, Brian Loughran, Lucky Loughran, the town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial. Proctor and his colleagues never spoke to him during the investigation, only did once Loughran was interviewed by a separate law enforcement agency, the FBI, and provided statements inconsistent with the MSP's narrative. 18 months later, after Miss Reed was already indicted and awaiting trial. Specifically, Mr. Loughran drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was no body on the lawn of 34 Fairview, no cars on the street in front of the house of 20 at 2:30 a.m. Mr. Loughran believes that he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30 a.m., Mr. Loughran saw a Ford Edge in the front of the Alberts' home that he had not been there an hour before, but which was then parked there. Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at this time. However, the Ford Edge was gone by the time Miss Reed arrived at the house at 6 a.m., and in its place, she discovered Mr. O'Keefe's body. Proctor, Buchnick, and Tully never made any effort during the actual investigation to track down Lucky or any information relating to the Ford Edge. Proctor also secretly made efforts to protect other family members during the investigation who had also had a role in Mr. O'Keefe's death. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28th/29th. But Proctor omitted his name from the official summary of Miss Nagel's interview, even though he listed all others who had been present at the house with Colin. When Miss Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorization of Julie Nagel's interview mirrored almost exactly what he typed up in his police report, except for the words Colin Albert. Or, as Mr. Cosgrove says, colon. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationship with any Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor's used his personal cell phone, to speak with Kevin, a CPD officer, instead of official channels, when he coordinated interviews of witnesses, even though CPD was recused from the investigation. Okay. Again, a little outraged here. Canton police was recused from this case because of impropriety, right? Kevin Albert is a Canton police detective who is the brother of Brian Albert. Why is Michael Proctor talking to Kevin Albert, who has nothing to do with this investigation, coordinating witness interviews? Suspicious. Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin Albert were out together drinking alcohol and driving in Proctor's cruiser on Cape Cod. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both MSP policies as well as various Massachusetts criminal statutes and further highlights the conflicted nature of the MSP's investigation. Moreover, because of their close relationship, Proctor, Buchnick, Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MPD and CPD collaborated to keep exculpatory surveillance evidence video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activities in CPD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. They demonstrated that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Miss Reed. Additionally, upon information and belief, CPD set its auto-delete function for saving certain surveillance videos from the Sallyport to 30 days, therefore assuring the immediately destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over a course of 3 years. How does that magically happen? Therefore, either the setting was changed to prevent defense expert from auditing the footage, which is when a 30-day setting was discovered, or the footage was obtained within 30 days of the 29th and withheld from the defense. Well, we know it's the latter, that they had downloaded it and magically found it in Proctor's file. The Indictments, Trials, and the Aftermath. Boy, this is such a great book, right? Miss Reed was arrested February 1st, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post a $50,000 for her bail, and the court imposed several other conditions release, including the loss of her driver's license. Oh, I didn't know it was loss of her driver's license. I just thought she couldn't drive. And stay-away orders from the O'Keefe family and John O'Keefe's home. Miss Reed was later rearrested on January 9th after being indicted for a second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. February 2023, her bail was reduced to $80,000 at the defense's request. Miss Reed was tried twice. Oh, say that 3 times fast. Tried twice by the Commonwealth. The first trial stated in April 2024 and ended July 1st after the court ordered a mistrial because of a hung jury. On June 18th, 2025, following another nearly 2-month trial, Miss Reed was acquitted of all charges associated with the death of John O'Keefe's murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Miss Reed was able to leave the court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Beginning in January 2022, the defendant's actions have been profound effect on Miss Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car, her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, tried twice, she has suffered years of intense stress and emotional harm and worried she would be imprisoned for the rest of her natural life for a crime she did not commit. Miss Reed suffers from both Crohn's disease and multiple sclerosis. As documented under seal with the criminal court, Miss Reed has undergone intense surgeries to manage her illness prior to the January 29th. And endured a blood infusion just months before Mr. O'Keefe's deaths. In an aftermath of the charges, 2 arrests, and during both trials, Miss Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, emotional, and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Miss Reed underwent dozens and dozens of documented medical procedures and treatments to address her health issues. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Miss Reed has suffered at their hands. Oh, MSP investigates, punishes Proctor, Buchnick, and Tully for their misconduct. Proctor wrote more than 1/3 of the police reports in this case, testified at state grand jury 3 separate times, interviewed every member of the Albert McCabe families, had possession of at least until March 14th all of John O'Keefe's clothing and all the taillight pieces found broken from the housing. Processed Mr. O'Keefe's Chevrolet Traverse the day after Miss Reed was arraigned, had access to and reviewed the ring videos, had access and reviewed the surveillance from C.F. McCarthy's, had possessions of all the CPD Sallyport and driveway videos, numerous other critical investigative activities. And yet, once again, evidence of Proctor's conflicts and lies became public. He was extricated from this case in an effort to hide from the jury and sanitize the compromised investigation while Miss Reed was forced to trial not once, but twice. Ultimately, Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County DA's office on July 7th, mere days after the conclusion of Miss Reed's first trial. Proctor was terminated from the MSP on March 19th. Upon a release from the district attorney and more implicating text messages from Proctor's phone, Proctor officially ended his appeal with the Civil Service Commission. On September 23rd, 2024, an MSP internal investigation found Yuri Buchnick failed to perform his supervisory duties of an ongoing investigation. On July 7th, Buchnick was transferred out of the Norfolk District Attorney's Office Detective Unit and reassigned to an administrative role in another division. On October 18th, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County DA's office, Michael Morrissey, to continue detective work on the Reed case despite his demotion because of his behavior on this case. Upon information and belief, MSP Trooper David DeChico and Jeff Kukowski were also disciplined for the misconduct associated with MSP's investigation into Miss Reed. Again, we're going to do a deep dive on these guys, but they pretty much stated what I would be stating. But we'll go over that anyways. Count 1, malicious prosecution. The preceding paragraphs are incorporated herein by reference. Proctor, Buchnick, Tully violated Miss Reed's Fourth Amendment rights by engaging in a malicious prosecution of Miss Reed by causing her to be seized by pursuant to a legal process unsupported by probable cause. The criminal proceedings against Miss Reed terminated her in her favor, which was acquitted of murder, manslaughter, and leaving the scene of the accident. I was reading the footnote. Nothing of interest. Hang on just a second. Hold, please. All right. Planting, fabricating things. Following her indictment by a grand jury, Miss Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required her to comply with numerous pretrial release provisions. The post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Those deprivations continued during Miss Reed's second trial, in part because Proctor's false testimony at Miss Reed's first trial. Among other things, Proctor falsely testified that when he saw the taillight on Miss Reed's car and Miss Reed's house in Dighton, he had large pieces missing and shattered taillight displayed at the first trial, as photographed February 1st, was in the same condition as January 29th. He and Buchnick never touched any part of Miss Reed's vehicle when it was stored in the Sallyport. He retrieved taillight pieces on subsequent searches at the Alberts home when he knew he had deposited or arranged for someone to deposit taillight pieces properly. Chris and Julie Albert were a loose accusations rather than friends. His statements and sworn affidavits all claiming that the Lexus seized at 5:30 and arrived at Diamond at 4:30 were typos. Thus, Proctor Buchnick Tully, acting under color of law, violated Miss Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court of Norfolk County, resulting in the loss of employment, reputational damages, millions of dollars of legal expenses, as well as serious emotional, physical distress and injury. In addition to award of damages for these harms, Miss Reed is entitled to attorney's fees, costs, interest, and punitive damages. Blah, 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 blah. Buchnick Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship, which he had disclosed. They always knew or should have known that there was a grave risk Proctor would wrongly seek to have Miss Reed charged, given the manifest bias evidenced in his text messages, which were sent to Buchnick, among others. Buchnick and Tully could have taken easily available steps to avoid a constitutionally deficient malicious prosecution of Miss Reed. Those measures include, but are not limited to, replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in Mr. O'Keefe's death. Safeguarding the crime scene and physical evidence, including Mr. O'Keefe's clothing, 47 pieces of taillight material, to prevent anyone from planting, manufacturing, or manipulating evidence. Initiating timely searches of the Alberts house, quickly seizing cell phones and other forms of electronic devices in possessions of the Alberts, McCabe's, Higgins, which would have prevented their later manipulation and destruction. People, we are only on page 36. I think we have 10 more to go. Okay, so buckle up, got 10 more to go. By not taking any of these measures, Buchnick and Tully permitted Proctor, and Tully permitted Buchnick to violate Miss Reed's Fourth Amendment rights. In other ways, Buchnick conducted Buchnick's conduct, constitution, I don't know that word, condonation of other acquiescence to Proctor's behavior or gross negligence, amounting in deliberate indifference. In these ways and others, Tully's conduct constituted condemnation. Okay, so that's just language. All right, let's get to, I was like, we need to get where the McCabe's and the Alberts and Higgin comes in. Okay, so here they come. Against Proctor, Buchnick, Tully, Alberts, McCabe's, and Higgins. The preceding paragraphs talks here in reference. Okay. As a part of their concerted efforts, and among their many other misrepresentations, the Alberts, McCabe's, Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed made inculpatory statements on the morning of the 29th. When they made these statements, the House defendants did not only because they were aware that Proctor, Buchnick, and Tully would also act similarly, but solely investigating Miss Reed. Proctor, Buchnick, Tully knew or should have known that the statements made to them by the House defendants were false, and that obviously and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beat up, fell back gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchnick, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Miss Reed, to the exclusion of everyone and anyone else. In furtherance of this plan, among other unlawful conduct, Proctor, Buchnick, and Tully agreed to continue to handle the investigation, even though they had personal relationships with suspects in the murder, which led to unlawful and favorable treatment of potential suspects. To continue to handle the investigation, even though they had biases against investigating the House defendants because the House defendants' ties to law enforcement. to continue to handle the investigation, even though they had exhibited an extreme and personal negative bias towards Karen Reed, to violate rules, policies, procedures, and all aspects of the investigation, to plant, manufacture, manipulate evidence, false documents, and commit perjury, to not secure evidence of the crime scene, to not investigate and obtain available evidence or a timely or appropriate interview suspects. Do not investigate Alberts, McCabe's, or Higgins. The McCabe's and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and text on their phones, which were later destroyed or discarded. Finally, Proctor Buchnick Tully coordinated with the Alberts McCabe's through Proctor's sister Courtney, who communicated frequently with Julie Albert. Acting pursuant to the plan, Proctor Buchnick interviewed the McCabe's and Brian Albert in a cursory manner and all of the same location midday on January 29th and Nicole Albert on February 3rd. Proctor Buchnick only interviewed Higgins once at his attorney's home and did not secure or search his phone or search communications between him, the Alberts, and the McCabe's. Proctor Buchnick did not search the Alberts' phone's home for likely evidence of Mr. O'Keefe's murder. Brian Albert and Higgins destroyed or discarded their phones destroying evidence of the murder and cover-up. As a result of the conspiracy between and among them, Proctor Buchnick and Tully never investigated the House defendants, and instead Miss Reed was wrongly arrested and prosecuted in violation of her Fourth Amendment rights. Proctor Buchnick Tully and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed's because Proctor Buchnick and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Miss Reed because of their personal and professional connections to Proctor Buchnick and Tully and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. The approximate result of Miss Reed's wrongful prosecution was her loss of employment, reputational damages, millions of dollars, blah, 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 blah. All right. Massachusetts Civil Rights Act. Okay, it's pretty much the same thing. Manufacturing, planting evidence. We're going to skip that. Common law malicious prosecution. By manufacturing, planting evidence, and not securing the crime scene, not searching the Alberts' home, the phones, ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor Buchnick and Tully caused Miss Reed's indictment, arrest, and prosecution. Miss Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor Buchnick and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. These criminal proceedings were insinuated with malice and evidence by Proctor Buchnick and Tully's knowledge that it was based on false evidence. All right. Infliction of emotional distress and harm, civil conspiracy, and furtherance of the conspiracy. Okay, some of this is just repetitive. All right, jury demand. Miss Reed respectfully requests a jury trial on all matters so triable. All right, we're at the end. XOXO, Damon Sellingson and Alan Jackson. Da 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 da. Okay. Wow, that was long, and I'm sorry it was so long, but you want to hear the tea? This is the tea. So, what is happening? As I stated, there is going to be a hearing later this week on, I believe it says Friday. Yep. Nope, wrong date. Yep, Friday the 21st is Karen Reed's status conference at 2 p.m. Now, a couple of things are happening that we didn't talk about that we were waiting for this, right? So one, the judge that was initially in Karen Reed's, the judge that was assigned to the civil case, John O'Keefe's family is suing Karen Reed for wrongdoings. Remember, we talked about Karen Reed and Alan Jackson are going to countersue, and they want all of these defendants brought in to this countersuit and have it all one big sandwich. They brought this to the court's attention that they were going to do this. I'd wondered if they were going to do this prior to their meeting this week, and here we are. Apparently, in civil cases, before they can go ahead and file it and put it on the docket, they then have to let the parties know, and the parties then have to respond. And so yesterday, we knew this was coming. The Alberts and McCabe's, I don't know if Proctor or Buchnick or any of them responded, but the Alberts and McCabe said that they're going to file a countersuit against this. So they're going to file a countersuit against Karen Reed for saying that they conspired against her. So it gets a little convoluted. So what does this sandwich look like? And is it all going to be compacted together? The McAlberts, McAlberts, people call them the McAlberts. The McCabe's and Alberts are wanting to take it to federal court. And if they do, if that works, federal court moves really quickly. And only problem is you don't get to go sit in federal court, but you'll get to hear smatterings of it. Currently, right now, this is in civil court within Massachusetts. It's not to federal just yet. So the sandwich looks like this: Paul O'Keefe, Peggy O'Keefe, John O'Keefe, the first, I don't know what the number is, and the niece and nephew are suing Karen Reed civilly for, I forget the terminology, but they're suing him for the wrongful death of John O'Keefe. Karen Reed's attorney are suing other parties that we just went through. So this is the top layer of the sandwich. Now we're in Karen Reed's civil suit. She wants to bring all these people in because all these people are then also going to testify in the civil case against her. So why not just bring everybody all together and consolidate into one? That is what Karen Reed's lawyers professed in the last meeting of this proceeding. So now here they've done it. So unfortunately, Judge O'Shea, who was initially assigned to this, is retiring. So they've got a new judge. I didn't look it up. I don't know his name. So a new judge has been assigned to this. So we'll get him, we'll get introduced to him on Friday. So layer one of the sandwich, civil suit, O'Keefe family suing Karen Reed. Karen Reed suing a whole bunch of other defendants. Now, then there might, probably not between now and then, there's going to be a countersuit from these defendants suing Karen Reed. And what does that look like? So currently right now, Karen Reed's civil suit against all the other people have not been incorporated into this case. So on Friday, we're probably going to find out if that will be incorporated, how does that look, et cetera, et cetera, et cetera. So that is the conclusion of Karen Reed's season. Is it season 3? Season 1, first trial, season 2, second trial. Now we're on season 3. Man, she needs some Netflix episodes to help pay for all of this stuff. So that is where we're going to leave it. It's been a long day. We've been recording for 2 hours plus here, plus the Brian Walsh hearing. So hope you're having a great day. Get outside, get some fresh air. That's what I'm going to do. Sun is shining. And we'll see you again tomorrow. What are we going to cover? I don't know. It depends on what's popping off, what's relevant, what's going on. As to what's popping off, we need to get an update on Brian Walsh and find out if they selected any jurors. We'll figure that out. And then we'll just see where we go. I've got a couple of things prepared, but boy, things just keep So like Corey Hopkins is a lawyer. She is trying to get the Karen Reed sidebars. She filed an injunction. She's got a hearing in reference to that because they're not giving her the sidebars. So now she's filed against them to say, you ought to give them to me. Why are they hiding these things? Everybody's hiding the ball. There's stuff popping off in Aiden Carney's case. They were the prosecution was supposed to file a response to the mega motion. It was supposed to be done by yesterday. They didn't. What's going on with that? He also has a new lawyer, special lawyer for his case as well. And then stuff going on with Aaron Spencer. So maybe we'll do Aaron Spencer tomorrow. Anyways, hope you have a good day. Remember to like and subscribe, please. And also set your notifications on so you know when I've posted something more recently. Ciao. See you later. Like and subscribe. I need to get to 50 by the end of the month. Thank you. Bye-bye. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.